Hello, my name is Tracey Elliot and I'm the Chief Examiner for the Medical Law and Ethics LLM module. The purpose of this short video is to provide you with an introduction to this module. Medical law and ethics is a fascinating area to study, dealing with some of the most contested and controversial topics of our time: assisted dying, abortion, and embryo research, to name but three. New technologies such as stem cell research, face transplants, and pre-implantation genetic testing have attracted considerable media and public interest. The aim of this course is to provide an advanced master's level grounding in medical law and ethics. It's really impossible to study medical law at this level without also thinking about the ethical issues which underpin questions about how we should regulate controversial medical practices. Hence, we study both on this course. This course goes beyond the standard undergraduate optional course by requiring students to acquire and use sophisticated analytical skills in evaluating complex legal and ethical dilemmas. Many of the issues touched on in this course are ones about which you will already have formed your own opinions or gut reactions. A key objective of this course is for students to learn to challenge their own and others' received wisdom and become aware of the importance of providing defensible reasons for their views and adept at doing that. This course is split into 4 sections: A, B, C, and D. Section A is entitled Basic Concepts in Medical Law. This section should be studied first because it introduces core concepts in medical law relevant to the other 3 sections. As well as giving you a guide to ethical decision-making, this section covers some of the basic building blocks of medical law, such as consent and confidentiality. The section begins with a basic guide to ethical reasoning as applied to medicine. There will not be a separate question on the examination on these different ethical approaches, but you will be expected to bring them to bear on the 15 substantive subjects which are covered later in the course. Next, we look at different aspects of the law relating to consent to medical treatment, examining questions of capacity to consent to treatment, and the provision of information about the risks of treatment, so that patients can make an informed choice about proposed treatment. Finally, we look at the question of confidentiality, concentrating particularly on times when patient confidentiality can be breached, and by the special issues raised by genetic information. Sections B and C then deal with core issues in the practice of medicine. Section B, Access to Treatment and Malpractice Litigation, is principally concerned with patients' access to treatment and the options open to them when they're dissatisfied with the care they've received. First, we consider the perennial problem of scarce resources in the National Health Service. The evidence appears to indicate that injecting more funds into the NHS is never likely to eliminate the need to ration treatment, and so we consider how this might be done fairly and what redress patients may have if they feel they've not received the treatment which they want or need. Second, we consider the avenues open to patients whose treatment has gone wrong. Most commonly, this will be an action in negligence, and we consider some of the criticisms which have been levelled at the clinical negligence system. Third, we look at the licensing of medicines, and again at the options open to a person who's been injured as a result of taking a pharmaceutical product. Finally, we consider a particular type of malpractice action, namely where the healthcare professional might be liable as a result of events which occurred before a child's born, perhaps because they carried out a sterilisation operation or prenatal tests negligently. Section 3, Legal and Ethical Issues in Medical Practice, then deals with 4 areas of practice where questions of consent and autonomy, which we have already considered in Section A, are prominent. First, we look at mental health law, which permits considerable intrusion into the freedom and bodily integrity of people who are classified as suffering from mental disorders. We look at the justifications for this and the protracted process of reforming UK mental health law. Second, we turn to the regulation of clinical research. Since research subjects may be subjecting themselves to some risk without any benefit to themselves, it's generally thought that they should receive special protection. For example, extra care might be taken to ensure their consent is informed and voluntary. Third, we look at organ transplantation, dealing separately with dead and live donors. In both cases, English law emphasises the importance of the donor's consent, and this has been further strengthened in recent years. We will consider recent legislative reforms in Wales and how the availability of donor organs might be improved. Finally, we consider end-of-life decision-making. Competent patients, patients who have the capacity to consent to treatment, and incompetent patients are dealt with separately. We look at assisted suicide, euthanasia, and the withdrawal of life-sustaining treatment. In certain circumstances, it's lawful for doctors to withdraw life-sustaining treatment from their patients, thus causing their deaths. But deliberately acting to end a patient's life is forbidden. We consider whether this makes sense. The final section is Section D, Legal and Ethical Issues in Reproduction, and is devoted to legal and ethical questions which arise from interference in the processes of human reproduction. A number of themes recur throughout this section. For example, at several points we consider the moral status of the embryo or fetus and the extent to which the law should be concerned to protect women's and men's reproductive autonomy. First, we look at abortion, which students are often surprised to learn continues to be a criminal offence in the UK. There are, of course, statutory defences which enable abortions to be lawfully provided, and we analyse these in detail. Second, we consider embryo and stem cell research. Should early human embryos be available as a resource for scientists, and if so, in what circumstances? Next, we look at the regulation of reproductive technologies, in particular in vitro fertilisation, treatment with donated gametes, and pre-implantation genetic diagnosis. Finally, we examine the regulation of surrogacy. So, who may wish to study this course? Well, this course has very wide appeal, but is likely to be of particular interest to those with an interest in medical topics, such as clinical negligence and mental health law, those with an interest in human rights law, and those involved in or with an interest in healthcare practice, where medical law and ethics have assumed a much more important role in recent years. Thank you for watching, and I hope that you will enrol on this course.